During closing arguments, if the defense fails to introduce a certain piece of evidence to support the fact that nothing was done wrong by this doctor, during closing arguments, can I point that out to the jury and show that, hey, if they had introduced this, maybe they would have a decent defense? Can I say something like that? You want to know the answer? Come join me for a moment as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. I'm here in St. Martin shooting video on a deserted island while my wife is picking seashells. It's a favorite pastime of hers. So I actually have a few minutes to share this great information with you. Okay, so now here's the question I raised. This is your medical malpractice trial. The defense has failed to introduce a certain document that I believe is favorable to them. For whatever reason, they have chosen not to introduce that into evidence and not to have any doctor or witness testify about that. And now, at the end of the case, during closing arguments, can I point out to the jury that the defense had every opportunity to introduce this document to support their case, and because they chose not to, that we clearly have a viable case, that we clearly have a meritorious case? You want to know the answer? The answer is no, I cannot comment on information that is not in evidence. How ridiculous is that? Or I should say, doesn't that make sense? So here's the scenario, right? You're in the middle of trial, the defense has not gone ahead and taken this piece of paper, a medical record, and now introduced it into evidence. They have not had any of their medical experts talk about what's contained in that medical record. Now, they know about the medical record, they've seen it before, they've seen it during the course of the lawsuit, and they have not had their own doctor, the doctor whom you have sued, the doctor who is careless, causing you significant harm and injury. They have not talked about it either. But I believe that this document clearly will show either that they have a good defense or that they don't. We're now at the end of trial, and during the entire trial, none of the witnesses have talked about this particular document. And now it's time for closing arguments. The defense goes first in a medical malpractice trial in New York, and at no time does he ever talk about this particular document, this medical record. Now, when I get up to talk and give my closing arguments, can I turn to the jury and say, ladies and gentlemen, the defense here had a document that they could have talked about, that they should have talked about, and the fact that they didn't, and didn't talk about the information contained in it, doesn't that reveal something to you? Doesn't that suggest they may be hiding something, that they didn't want to introduce that to you? Now, the flip side of that coin, if the defense had an opportunity to rebut my argument, which they often don't, but if they did, they could turn around and say, hey, if this document was so important, Oginski and his client had an opportunity to introduce that on their own case. And you know what? He'd be absolutely right. If there's such an important piece of evidence or document that the defense has not introduced, I have an opportunity when I'm questioning my witnesses on our case to go ahead and introduce whatever I think is important. So yes, that's true. I would have had an opportunity to introduce a document and don't have to wait or rely on the defense to do that. But now as a strategy, I've decided I'm not going to touch it. It doesn't help me. But now the defense has not introduced this document and I want to talk about it. Well, that raises two problems. The first problem is that that document is not in evidence, which means I can't talk to the jury about it because it's not in evidence and no witness has talked about it. And because of that, if I were to go ahead and refer to this particular document, the defense would be fully within his right to jump up out of his seat, yell out, "Objection, Judge!" and now explain his objection that this document is not in evidence and it's improper for me to comment on something that was not introduced in evidence. And the judge would be correct to turn around and say, Oginski, sustained, meaning I agree with the defense attorney's objection, and Oginski, you are not to talk about it. But the bottom line is, if the defense has not used this particular document to help their case, I can't use it to argue to the jury, listen, there's a key reason why they didn't introduce this document, because we know it helps us and our case. Can't do it. If it's not in evidence, I can't talk about it. So why do I share this quick information on this beautiful day today here in St. Martin? I share it with you because in all likelihood you're watching this since you wanted to see the gorgeous scenery behind me and see where I'm shooting video today. No. I realize you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.